Welcome to Fourth Right, Reader Feedback Edition, and the 2022 Supreme Court decision reining in the Environmental Protection Agency. It is a decision that will hopefully impact other federal agencies and push back on the growth of the administrative state and the executive branch power at the expense of the legislative branch of government. First published Thursday, July 7, 2022 in the Spokesman Review, here it is, headlined, West Virginia v. EPA ruling gets back to basics. A federal agency has been reminded its purpose is to administer laws, not make them. Progressive voices claiming the current U.S. Supreme Court is rewriting laws to fit an extremist agenda might just be longing for the good old days when they assumed courts would do exactly that for their special causes, treating the Constitution as a malleable tool instead of the original contract with the people. And Congress has been reminded of its duty to be specific when delegating responsibility. Recent court decisions reining in the administrative state are a welcome change from decades of an activist court making law from the bench. The U.S. Supreme Court majority opinion in West Virginia v. EPA addressed the question of, quote, agencies asserting highly consequential power beyond what Congress could reasonably be understood to have granted, end quote, according to the majority opinion authored by Chief Justice John Roberts. But if all you read is mainstream media headlines, you might think the ruling was about activist judges who love power plant emissions. Conservative judicial philosophy is concerned with the original reading and intent of the Constitution, as opposed to a judicial pragmatism assuming an ever-evolving meaning. The minority opinion signed by Justices Elaine Kagan, Sonia Sotomayor, and Stephen Breyer begins by emphasizing the intended purposes of the agency. Its focus is on the ends without regard to the constitutional validity of the means. But the question answered by the court was not whether the specific EPA rules in question are correct or useful, but whether EPA was given authority by Congress to make rules with such major impact. The ruling is likely to affect other federal agencies that have accumulated increasing power under a judiciary progressive activists thought they controlled. And Congress will have to step up and make tough policy decisions instead of reacting when the unintended consequences of agencies operating under vague guidelines slam their constituents. So much easier to say, oh, don't blame us, it's those darn bureaucrats. It's a tough balance for Congress. Legislative micromanaging of rulemaking isn't practical, and monitoring the impacts to close the accountability loop is essential but difficult. And so Congress has allowed certain laws to be challenged by citizen lawsuits as another path to accountability. Such citizen suit provisions are included in a variety of statutes, including environmental, housing, civil rights, and the Americans with Disabilities Act. Relying on lawsuits led to the Equal Access to Justice Act, the EAJA, which has been used and abused by nonprofit special interest groups to force policy changes through sue and settle negotiations. EPA has been a particularly eager use of lawsuit-driven rule changes. So much easier to say, don't blame us, it's those darn judges. Supporters of sue and settle embrace it as an efficient strategy to break through bureaucratic inertia. A lawsuit is brought by a concerned citizen group, often a nonprofit with lawyers on the payroll. The sued agency declines to defend itself and negotiates a settlement approved by the courts. Games can be played on both sides. An agency might benefit from breaking an internal stalemate. The nonprofit may be awarded legal expenses to keep them in the game. According to the most recent report to Congress, in fiscal year 2021, federal agencies reported paying more than $112 million in awards of attorney's fees and other expenses under EAJA. The EPA under the Obama administration set records for expanding regular authority under cover of "the court made me do it" with sue and settle rulemaking in response to special interest groups. According to 2013 and 2017 studies by the U.S. Chamber of Commerce, using public notices of consent decrees as published in the Federal Register, Bill Clinton's EPA settled 28 lawsuits in his second term. The EPA under George W. Bush settled 38 in his first term and 28 in his second term. Under Barack Obama's leadership, the EPA signed 60 consent decrees in his first term and 77 in his second. Sue and settle was taken off the table in 2017 under Secretary of Energy Scott Pruitt during the Trump administration and brought back under President Biden. Current EPA Administrator Michael Regan described policymaking by settlement in his March 18, 2022 memorandum as, quote, the most practical, economical, and efficient path forward while also serving the public interest, end quote. But efficiency is not the point. Our system of government was deliberately designed to be clunky in the interest of assuring that all interests are heard in the public square. Sue and settle takes negotiations behind closed doors and subject to pressure by the currently powerful. It may be fine while your people hold the keys to the room, but not so comfortable when the shoe is on the other foot. Congress makes the laws and the executive executes, but the dozens of agencies in the executive branch have grown their own interests to protect. Whether you call it the administrative state, the fourth branch of government, or the swamp, the EPA and other agencies operate on delegated authority. They are not meant to be policy-making bodies. Maintaining a balance of power between Congress's legislative responsibility and executive branch authority is where the judiciary rightly steps in, saying, don't blame us, just follow the Constitution. Well, there were a number of positive responses to that. About time the EPA was reined in, climate change, environmental whack jobs will be the death of this country. As is usually the case, from another writer, the progressives are so busy being emotional over the topic they fail to see the court's responsibility to concern itself with the process and foundation on which an issue rests. And then now from some of the naysayers, which are a little more interesting to come back with, but one of them was that my disagreement with your article today is that justices that claim they are guided by the specific text of the Constitution, regardless if they are progressive or conservative, do so based on their individual interpretation of that text. Somehow you try to support that textual interpretation only done by a conservative justice. Come on. Well, of course, individual justices are applying their interpretation, but we tend to describe the conservative wing of the court by their attempt to discern the original meaning and intent of the founders. That's the interpretation they're making. The progressive wing tends to be more willing to interpret the Constitution as a living document based on current context. But that's a much larger conversation for another time, but I appreciate the point of feedback. Then from another fellow who's often a naysayer, there was this. Believe it or not, I partially agree with you. And I have to say, I love naysayer comments that start off like that. I love it when we find some kind of common ground somewhere. And I agree totally with his first paragraph. There is a figurative army of lobbyists on K Street in D.C. whose job it is to influence agencies in rulemaking. These lobbyists are generally representing business or business associations. Their work is done out of public scrutiny and often results in rules contrary to the public interest. I would agree that Congress needs to step up and take more responsibility in this arena, but given the gridlock and acrimony in Congress, primarily caused by one side, there is little chance of this happening. Okay, maybe I don't agree completely, because I don't think it's just one side that's causing the gridlock. There's two sides to that dance. And the problem is, as I mentioned up above, is that those sue and settle negotiations, those are also done with special interest groups. Now, business special interest groups have the best interests of their members at heart. Groups that claim an environmental basis, they have a good heart. They may be off. I may think that they're looking too narrowly at any one thing, but again, every one of those special interest groups has a narrow special interest. And what we need is more looking at that whole big picture, which is what Congress is set up to do. It's why Congress has so many different voices that are speaking there. It's why the diversity of voices in Congress matters. Not just diversity in an ethnic, cultural way, but diversity in a political point of view way. And that's how we come up with that larger public interest. And that's why agencies making those rules and a sue and settle are so much of a problem. And that's a problem for everybody. He went on to disagree that the Supreme Court, saying that the Supreme Court has been a political entity since 1804 with Marbury versus Madison. You've put 5 people together and you find politics breaks out. That's just the way it is. He does make a point again about the EPA case coming at a time when, I'm now quoting from his writing, when the country faces several challenges that cannot be left to the states to solve. One example is the crisis in the Colorado River Basin. And so he finds it absurd to think that somehow we'll be able to work together to resolve this problem. Given the Supreme Court's EPA decision, how can the federal government respond? And I'm not sure it can, is what he says. So he's right. I mean, the purpose for the federal government is to figure out how to mediate between states' interests, but we are a republic made up of individual states that are not always going to have the same interest, and who are allowed to have their own individual interests. But his closing paragraph is also one that has some points of common ground we could find. He goes on to say, surely the ultimate responsibility to resolving this situation belongs with Congress. Congress has been abrogating its authority to the executive for many years. Totally agree with that. One egregious example is the resolution supporting aggression and fighting terrorism that was passed in 2002. This open-ended, ill-defined bill has been used by presidents since to justify military action without congressional approval. And I agree, I have some problems with that bill. It's every time we are under attack is when the federal government expands. It started with a civil war and it's expanded ever since. But he closes with, so long as very rural states with very small populations can hold the rest of the country hostage to their wishes and interests, I see no way for Congress to resolve this issue and reassert its authority. Well, I prefer smaller government operating as locally as possible because that concentrated power attracts concentrated lobbying. And Congress and state legislative bodies have indeed been avoiding their duty to make tough decisions by passing the buck literally to agencies. But the core of the founders' intent was a recognition of the sovereignty of each state and a limited role for the federal government. So the process question is, when must the federal government step in to mediate or to coordinate policy between states, and when do we simply have to accept the differences? Our system is quite deliberately set up to provide small states with the same voice as the large states. And given the results we see in states where there is an imbalance of authority, where a single metro area has the ability to run policy roughshod over the rest of their state, for example, New York, Illinois, Washington, I think we can be glad the federal government is reined in, or else we'd be in the same boat as an entire state or entire country. So I do appreciate each of those who took the time to read and respond to the column, especially thoughtful feedback, even if we have a difference of opinion, is always appreciated. If you'd like notification of new content on Forthright, please subscribe at Sulani Madsen, Substack, still free to subscribe in 2022.